Thank you everyone so much for being here today. We are joined by Denise Marshall, who is the CEO of COPA, Council of Parent Attorneys and Advocates, as well as Celine Almazan, the legal director at COPA. So we're looking forward to the information you're going to provide today, and we'll be going over questions at the very end. So feel free to put any in the chat as you think of them.
Thank you so much, Peyton. It's an honor to be here with all of you today. Some of you I recognize, hello, and others of you, it's nice to meet you. I'm Denise Marshall, COPA's CEO, and I am a non-attorney. So we been working in this field for a long time. And I started off as a positive behavior support specialist in the schools, and then moved on to do more about training and working through different advocacy organizations like COPA, but got my start here in Maryland. And so I was particularly excited to see this law passed and to, to be able to be part of its implementation. And I'll turn it over to Celine Almazan, who's our other presenter, to introduce herself.
Hi, everyone. I'm Celine Almazan. I'm the legal director for COPA. I recognize a lot of you, so good to see you all. And I know that a lot of us were involved in the passage of this law, and I think it's very exciting that it's getting off the ground. Hope we can shed some light on UPL. I've had some conversations with Peyton, and it's an honor to be here. And thank you, Peyton, for inviting us. Appreciate it.
Great. Well, I'm just going to tell you a little bit about COPA, or the Council of Parent Attorneys and Advocates, for those of you who may not be familiar, but we are a national organization, and we work together as advocates, parents, students, attorneys, and allied professionals is our new term for related professionals, to try to broaden the term to anyone who's really working on behalf of a student with a disability. And we have 3,600 plus members across the country, almost 40% of whom are advocates. So although there is, and we'll talk about this a little bit further into the training, there's not really a set definition of the profession of advocacy or any rules that they live by across the country. There is a growing practice, and COPA has been at the forefront of that movement for quite some time. I think we're in about our 18th year of providing training to advocates on different levels, and many of you have taken that as well. So one of the things that is important is, to make sure that people have information, because information is power, and COPA believes that our movement and COPA is a place where our movement finds its strength. So here the information that we want to impart, as Celine said, is for a competent special education advocate to recognize their role, really, and recognize what lines there are, although they're not always as bright, and we'll get to that too, but as we'd like them to be. But what an advocate should be doing, can do in their under the law, in their role. I think it's generally recognized that an advocate is essential in many times to help families understand their child's needs, sometimes to really be able to understand those needs as it relates to what their rights are under the law, and to help them meaningfully participate in their child's education. And that can mean being at the IEP meetings, or understanding evaluations, learning what best practices. Some of our advocates and families know more about specific practices, like how to teach a student with dyslexia or positive behavior supports or reading intervention in general than many other professionals that I've met. So people really dive into the specifics and can be very, very helpful to families throughout the process. It's generally kind of understood that in doing so, they would help them understand and make decisions about ways to proceed, strategies to use. Advocates, while, like, as I said, very useful and someone that we absolutely recognize as a profession and have tried to elevate that profession through all of the different training and activities that we take. And we often, in almost everything that COPA does, we pair a non-attorney advocate with an attorney, much like Selena and I are doing this training today. But on the whole, advocates are not certified or licensed. They do not have an enforceable ethics code. There's no statutory confidentiality privilege. Well, it's hard. I don't know why that's hard for me to say. But a lot of times you will hear about attorney privilege, which means that whatever, which I understand to mean whatever's being said between the two parties stays confidential. Advocates don't have that same right typically. There might be some exceptions to that, but on the whole, we're talking just as a typical thing. There's no rule that provides them with that right. And there's no required educational standards for competence that are recognized, like, for example, for attorneys, they have to pass the bar. For speech and language pathologists or an OT or a PT, there are you know license exams and things that they need to do to demonstrate their competence prior to practicing. There's really nothing that exists on the in the field for special education advocates. And I know that a lot of this is probably not news to you, but we wanted to share it as background. So again, although there is not an enforceable code of ethics, sorry, I was moving on to the next slide there. COPA did come up with a voluntary code of ethics in 2010, and it's interesting because that code we've had it for 15 years now, and it's been used all across the country, both by advocates and also by some states in looking at the question of whether they could put anything in place to regulate advocates, the practice of advocacy, or how to get somebody approved to work as an advocate. And it's stood the test of time. Recently, we've had some discussion about adding the use of AI, artificial intelligence, but we have not yet done that. And so this is a link to the Code of Ethics on our website. Basically, the kinds of things, if you're not familiar with it, that it goes over. There are 5 sections, I believe. Yep. Competence, that some examples under that are that they know the limits of their competence, that they know, and that could include saying for example, I am a non-attorney. I can't provide that kind of advice, or that they exercise reasonable care. Some other categories that are under our code of ethics are the responsibilities to the clients, helping them make informed decisions. Again, letting them know when something is beyond their capability or beyond their understanding or beyond their knowledge, and just being honest and forthright with that information. Conflict of interest is the third area, and that the advocate is obligated to place the interests of the client ahead of their own interests, or ahead of personal gain, for instance, if there are fees involved. and to disclose anything that might, become a conflict of interest. Communication, never knowingly mislead any others and use, I put in there as an example, and we're going to talk about how the use of AI got a particular advocate in another state in hot water, and what is important to know about that. And lastly, the last category is professionalism, which really says that advocates are expected to adhere to all the applicable laws of the jurisdiction in which they practice. And so that's one of the reasons why we're having this training today, is to help you understand what the law does and doesn't say about the unauthorized practice of law, and what to do with that information in your practice. And to review relevant records and information before offering specific assistance to a family. I don't know, I could probably would love to get $1 for every time I've said over the years, well, I don't know the facts of that situation. I haven't read their records, and I don't know the child, so I can't really speak to that in particular. I can say generally that in a situation, or when a family is faced with a manifestation, hearing, they might want to consider this, but I don't know that child. So that's an example of being very clear that unless you've reviewed all the records, we shouldn't be offering people specific information. And then just treating everyone with candor, fairness, and civility. So those are some, general guidelines that are in the Code of Ethics, and we encourage folks to review it and to consider using it as a guideline for yourself if it's helpful. So that brings us to the question, since we're talking about avoiding the unauthorized practice of law, of what does constitute the practice of law? And the fact is that it's established by lawmakers, and it can vary from one jurisdiction to another. Whether the definition, whatever that definition is, it's intended as a consumer protection kind of a guideline, so that families are not receiving information from people not authorized to provide that level of information. One analogy people have used is similar to, the medical profession. It's just asking your next door neighbor or your mother is not the same as, or Googling it, it's not the same as getting advice from a doctor. And much as people like to try to do that when it comes to the law, it's not the same as getting advice from an attorney. And so distinguishing the practice of law from the practice of advocacy is important for that reason. So if we're saying that the practice of law includes legal services, well, what are legal services? And typically that can include preparing legal documents, providing answers to legal problems or issues, and appearing in a representational capacity. And that's one that we'll talk about a little bit more, because there seems to be a lot of confusion about the definitions of providing support and guidance versus representation. Is there a bright line? No, not necessarily. However, there is generally understood difference between advice and information, and whether or not you're just making recommendations or providing information so that the family can understand the situation and make a choice, or whether or not you are providing legal advice and trying to apply the law to the facts of the case. I know when I first started out with this, and I was working as a behavior specialist, it might even have been you, Celine, that said to me, someone asked me something like, tell me about, has the child been out of school? For how often has the child missed school? And I said, well, they've been out of school for a pattern that adds up to over 10 days, and therefore it's a violation of the law because and you said, okay, let's just stick with the facts. What are the and then I'll make a determination whether or not it's a violation of the law. And I think that's hard sometimes to stay on the line and to recognize that what we understand as a law in our head, it's sort of like, I also often think of the analogy to what my husband calls armchair diagnosis. It's like I've been doing this long enough where I do recognize some of the symptoms of some of the most commonly diagnosed either disabilities or mental health issues. But that does not make me qualified to make that diagnosis or to say with absolute certainty. I can say what I've observed. I can say what the facts are about the number of times the student has been removed from the classroom or sent home or expelled or suspended. I'm sorry. And I can say that the law is that if it adds up to a pattern of more than 10 days, then that could be something that is considered to run against the law. But that's not for me to say because I'm not an attorney and I'm not a judge. Or I'm not a hearing officer in that case. So typically what we've seen, and Celine's going to talk about some of the cases and what different states do, but generally the claims and the cases have applied to representation in a hearing. Those are, there's I don't know of any that have to do with providing advice to a family or helping them prepare for an IEP meeting, or just explaining the law to them. But again, we don't often know where where a claim of UPL might come from. So if there is one, again, we recommend that you consult with an attorney who can help you distinguish what the facts of the case are and whether or not there's what your risk is, I guess, in that situation according to the laws of Maryland, as well as any kind of court cases that have been determined in our circuit or in relevant areas. Often people want to know, and in some of the cases that Celine's going to talk about, they specifically looked at what does the IDEA say. And it does say that any party to a hearing conducted pursuant to subsection F or K, blah, 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 should be accorded the right to be accompanied and advised by counsel and by individuals with special knowledge or training with respect to the problems of the children with disabilities. Again, this is the language of the statute, not mine. I wouldn't use the word problems, but except whether the parties have the right to be represented by non-attorneys at due process. This is determined under state law. So specifically, the IDEA leaves this question about whether or not advocates can represent at due process hearings to state law. And with that, I will turn it over to our legal director, Celine.
Okay, thank you. So I guess let me put it into context a little bit. We know that UPL can be used as a sword by school districts. And so I'm going to, put that right out there because historically, going back to the early 2000s, we've seen instances where families, in their desperate attempt to get services for their children, end up in federal court and get, in a quagmire because they're not lawyers and they cannot represent their children in federal court because they're not lawyers, right? You're not allowed to do that. And that's how we got Winkleman versus Parma, the Supreme Court case that lays out that parents also have due process rights under the IDEA, which they can prosecute on their own, but they just can't do it for their kids. So UPL can really be a sticky wicket that school systems have used historically against families and against advocates. And so because of that, I do think it's important to be careful. And one of the things, because those of you who have known me for a really long time, I've been around, like forever, and I've known Denise forever. And this is how I always look at it. I was a legal aid lawyer when I first started out, very young, and black hair, no gray, and no glasses. And I remember when we used to have to do the intake line way back when in 1980s. And one thing that was drilled into my head from my chief attorney was, when you do the intake line and you talk to people on intake, you may not give legal advice because they could rely upon it, get in trouble, and then you could lose your law license for giving legal advice to someone who is not your client. So that was drilled into me. And so almost 40 years later, whenever I talk to a parent on the phone, I am very, very careful that I do not give advice. I tell them what the law is. I tell them what their remedies might be, but I do not give an opinion on whether or not they have a case or whether or not there's been discrimination. Actually, I talked to a parent the other day who called my law office and was frustrated with me, like really frustrated with me, because she kept telling me she had a discrimination case. And I kept telling her, I don't think you need a lawyer right now. I think you need someone to help you figure out what your child needs. And then you might need a lawyer. And I don't know if it's discrimination. And she later called me back and was, pleased with the information and the referrals I gave her for an educational consultant. And she had, dialed it back considerably. But, families, when they call, and you all know this, you've been advocates for a while, they're not happy and they're very frustrated and they want an answer. And so when I talk to Peyton about this training, one of the things that's always in my brain is I try very, very hard not to give legal advice to families who are desperate for advice, because I could get in trouble for that. So just think about that when you're advocating, that as it applies to you, you can't give that advice. You can't give them something that they could rely on. You can give them information, and under this law, you can give them guidance and support. And many of you, I know enough when you get into a position when it's time to refer to a lawyer for additional assistance with families. So next slide. That was my soapbox. Sorry about that. So there are laws where there are states where non-attorney advocates can represent at due process. I believe one of them is in Indiana, one of them is in Texas, and the Texas law, when it was originally passed, said that you had to have like the certification that the Department of Education would sign off on, that you had enough training and knowledge in order to represent families in due process hearings. In Oklahoma, there is no due process representation by non-attorney advocates. And I'll just do a little bit of, lawyer bashing. I'm representing a family right now in Oklahoma that one of COPA advocates convinced me to do in March when I saw her in person at the last COPA conference. And the Oklahoma has very, very strict laws on who can come in and assist families. And so I had to pay like several $100s in order to get the Oklahoma bar to give me this certificate so that I could represent with local counsel this family in Oklahoma. So it's very regulated in Oklahoma, and a lot of money that I paid in order to represent this family. So I think that, part of it is that bars don't want outside counsel or want to make sure that whoever comes in knows what they're doing. And that's where a lot of the UPL prohibitions come from lawyers crossing from state to state, representing representing people just in general when they're not admitted to that local bar. Next slide. Tennessee and California, you may not represent in a hearing. There is actually an attorney general's opinion, I guess back from 2017, that specifically says that non-attorney advocates cannot represent families in due process hearings. In Virginia, you are allowed to, as a non-attorney advocate, to represent families in a hearing. And actually, I probably shouldn't even be using the word represent, because if you're not a lawyer, you really can't represent, but you can, as a non-attorney advocate, prosecute in the general sense of that word, assist families in putting on their case in order to meet their burden of proof, right? So I think we have to be careful on the language that we use, because only attorneys can represent families, a representation of a parent. Next slide.
Celine, you're muted.
I don't know how that happened. Thanks. So in Virginia, there are a series of cases in federal court that, I don't know how to say this word, Powhatan County School Board brought against a family and an advocate who assists families in Virginia. And as I said at the outset, if a parent is trying to do their own case pro se, they can advance their own issues, but they cannot do it on behalf of their child because they're not a lawyer. Similarly, if you are an advocate and you are a defendant, Powhatan County School Board has sued you, you cannot represent or claim to file pleadings in court on behalf of the other defendant, in this case, the Skinger family. And this advocate did get into a lot of trouble from federal court judge for doing this, filing pleadings on behalf of the family, trying to attend settlement conferences on behalf of the family. And the court did sanction this advocate $6,000 for unauthorized practice of law and for violating a court order. The case is incredibly dense, and I've spent some time on Pacer, the free services where you can look up court cases, trying to figure out what went wrong. And what went wrong was this advocate was filing pleadings on behalf of the family, filing pleadings on her own behalf, which then she would be pro se, right? But in this case, she said that her services, in order to get around this unauthorized practice of law issue, she said that her services were really a related service, and she was providing parent counseling and training, which the court rejected out of hand. And Judge Payne, who was the judge, I think, in this case, said that only licensed attorneys can represent parties in federal court in Virginia. And so this is not the only situation where this advocate did find themselves in some trouble for continuing to advance this idea that they were providing a related service to the family as parent counseling and training. Next slide. One of the pleadings that this advocate filed, I think it was through the usage of AI, and there were 42 fake citations in this brief that she wrote and filed. And the judge was so not happy with this turn of events, especially because the judge was already upset about her the allegation of unauthorized practice of law, and was really upset when this brief was filed that had 42 fake citations. And yeah, I mean, some of the language in here is that it serves to make a mockery of the judicial process, and it was an enormous waste of judicial time to try and find these cited cases, only to determine that they didn't exist, and that they were neither real authority nor were they binding. So not only was this advocate in federal court filing briefs on her behalf, on behalf of the parent, but then used AI. And, you know, big white shoe law firms have gotten spanked for doing this too. So, you know, partners have signed off on these briefs and these filings in federal court all across the country, and have had to do, you know, mea culpa in front of federal judges and state judges all across the country because they didn't check the citations to make sure that they were right. So it's not just this advocate, but it is happening all over the country with the use of AI. Next slide.
Can I actually say one more thing before I move on to the next slide? And I think in the practice of advocacy, that's why we always say, you know, get the document that is being referred to and read it yourself, because people often, whether it's related to a court filing or not, you know, will reference, as you know, policies or other kinds of things that sometimes don't exist. So I think in general, that's an important rule to keep in mind.
Yeah. Yep. Okay. Next slide. And so there is a history of this advocate being sanctioned in other cases in federal court in Virginia. And now there is a permanent injunction against her from participating in IDEA cases in federal court in Virginia. It really is a shame that this happened. It just serves that you need to be super careful. This advocate is now in the Fourth Circuit, and I did read some of the pleadings the other day, and is going to continue to have difficulties even in the Fourth Circuit. Next slide. So I'm sure that a lot of you on this meeting are not headed into federal court and just want to know what you can do and not do in IEP meetings, in mediations, resolution sessions, and facilitated IEP meetings. So Maryland does have, you know, laws that say that it is a misdemeanor to engage in unauthorized practice of law, and it is enforced by the Office of the Attorney General or the Attorney Grievance Commission. And this does apply to people who hold themselves out to be attorneys, people who are not licensed in Maryland, people who may have lost their law license and continue to hold themselves out as lawyers. And so UPL is as defined as practicing law without a license, providing legal advice without being a licensed attorney, which might apply to advocates, and assisting others in practicing law in violation of professional conduct rules. So even if you are supervised, if you're a paralegal and you're supervised by a lawyer, you still can't engage in UPL. That's no defense and it's no excuse. Next slide. So anyone who is practicing in Maryland without a license, or if your license has expired, is considered to be engaging in unauthorized practice of law. And as I said, paralegals and support staff cannot provide legal advice or make strategic decisions or perform other actions that usurp the attorney's role. Now, UPL is UPL if you help a domestic violence victim fill out a paperwork for a restraining order. Is that considered unauthorized practice of law? I think it depends if you're filing that form for a temporary restraining order, protective order. If you're assisting that person and the person is filling it out on their own, or if you are filling it out and then signing her name, that it's not really that person that's filing it, that it's really you could get into trouble for UPL that way. If you're attending an IEP team meeting and you're citing what the law is and then telling the IEP team that they are violating the law, that might be UPL. You are there to give support and guidance to families, and goodness knows you need it at the IEP team table because it's a very lonely place to be if you're a parent. Those of you who are parents know that. And so you just have to be careful that you're not, besides stating the facts, then saying that there has been a violation of the law. Next slide. Oh, okay. An attorney can't knowingly help another person or engage in the unauthorized practice of law. So if you're working with an attorney can't help you pull one over on anyone. And practicing law without a license is a misdemeanor and fine up to $5,000 and a year in jail. And that really applies to a lot of people who hold themselves out to be lawyers, but it is something to be mindful of. Next slide. So I did look up the statute under Maryland Business Occupations and Professions. This is section 10-601 in the Maryland law. And it essentially says what I just outlined is that a person may not practice, attempt to practice, or offer to practice law unless they're admitted to the bar, that you cannot collect and distribute money, you can't perform any other act that is necessary to conclude the affairs of a law practice. You can do that in order to wrap up a law practice, but you cannot do anything that looks like you are practicing law. And so that's what the Maryland code says. Next slide. And then there were some, notable cases out of New Jersey. The Aarons case, this was an advocate, very successful advocate in Delaware and in New Jersey, who was sanctioned for the unauthorized practice of law, as well as an investigation of advocate down in Florida for the unauthorized practice of law. In the early 2000s, when the Winklemans were trying to get representation, the Ohio State Bar went after them for unauthorized practice of law, as well as another family, the Woods family, for unauthorized practice of law as well. That was the Bar Association going after them. And, you can definitely see the partnership between bar associations and other bureaucracies within a state, that if a complaint is filed, the Bar Association could pursue it. And so in Ohio, I think what happened was that the school systems did not like these families who were trying to advocate on behalf of their children, couldn't find a lawyer, and were really doing what parents do in order to assist their family. And the Ohio Bar did investigate them. Ultimately, didn't do anything with the charges against them, but this was before the Supreme Court made the decision in Winkleman. But those Ohio families in the early 2000s were really put through the ringer for trying to advocate for their families. And so I think that that's a good example of using UPL as a sword. And so, but that's why you need to be careful that you don't run afoul, because, you know, once you are successful with families and helping them get the services that they need, that's really when school systems start looking for a way to get rid of you, right? That they don't want you to be so successful. And I would certainly hope that that doesn't happen in this state, but we all just need to be aware of that and just be careful. That's all. Next slide. Yeah. So if you give a parent legal advice and you're wrong, and they may have exhausted their special ed options and may have no other options, and that also applies to us lawyers, why we shouldn't be giving legal advice to families that we don't know and don't know what their circumstances are, because they could rely on that, and then they could get themselves in trouble based on whatever advice that a lawyer gives them. Next slide. So to avoid UPL, really need to look at a state's UPL, unauthorized practice of laws and past court decisions. The Virginia case in federal court gives a good roadmap for how not to get yourself in trouble like that. Never claim to practice law or offer any kind of legal conclusions. Stick to providing factual, regulatory, or procedural information. Let parents make decisions based on the information provided, and also consider liability protection, such as incorporation documents or insurance, which I highly do recommend that that insurance. And it's not to scare you all into not doing your very best for families, but just to be mindful and to be careful. And honestly, that's also what lawyers do too, in being super careful. And those of you who've been to a COPA conference, you know that when people start asking specific questions, the presenter should be cutting it off and saying, I can't give you additional information, because that would be giving you legal advice, and there's no there's no relationship there. But and one of the things that lawyers also do is allow parents to make decisions on their own, because it's their life, it's their child, and you shouldn't be making decisions on behalf of your clients, even if you're a lawyer. So I think that we are at questions, and we'll open it up to questions, unless Denise has something else to add.
Nope, I do not.
Well, thank you both so much. One of the questions I had as we were going through the presentation is, there are these terms that are used at IEP meetings that could also be considered legal terms. So I'm thinking of FAPE, LRE, things that people are familiar with at the IEP table. When is discussing those kinds of topics, when would you consider that verging on UPL?
I think I'm trying to think, when you're at an IEP team table and you're talking about what a student might need and whether or not a school can provide those services, couching it in what the IEP says, what the student might need, what we can reasonably expect from a school and whether or not they can meet those needs. I think all of that is appropriate at IEP meetings, questioning whether or not a student is unnecessarily segregated in looking at LRE questions. I think all of that is okay at an IEP meeting in the role of guiding or supporting of a family. And I've been in meetings with advocates and really the questions really surround the IEP and the services. And that's, those are things that advocates have experience in that I do not. And so the role of an advocate in an IEP meeting is to assist the parent in developing an IEP document that can confer educational benefit and ensuring that under Andrew F, that those goals and objectives are challenging and ambitious. But yeah, I think it might cross in to UPL if an advocate then says, oh, then we're going to send you a 10-day letter and we'll see you at a hearing. That I think might be problematic. That might be problematic.
Thank you. Another question we have in the chat is, can an advocate work with a family during a manifestation meeting without an attorney? Or is there any special considerations for those types of meetings?
Yes, I think you can at an MDR. And again, it is the information that you're trying to present to the team in order to get to the question of whether or not it was a manifestation and make sure that all of that information is available to the team as part of the support and guidance that you bring. There were some advocates years ago that got into a bit of trouble for at the end of an IEP meeting saying, we're going to see you in a hearing, we're going to take you to a hearing. And this is before advocates could represent families in Texas in hearings. And so you just need to be careful. And honestly, those of you who have been in an IEP meeting with me, you know that at the end I say I'm going to, we're going to look at legal options, and that's it. I never say we're going to, go to hearing. We're going to look at legal options. But even for advocates, just saying we're going to look at legal options, it might be crossing into UPL. So you just need to be careful there.
Something else I thought of with that is when there's a question that's posed to the entire IEP team, answering that question wouldn't be considered UPL if attorneys on the school side are also answering that question.
Right.
So with MDRs, when we're asking about whether a behavior was substantially related to their disability, everyone's answering that using their own perspective.
That's right.
Right.
That's right. Yeah.
Or pointing out where they saw that in the evaluation or in a written document. So yeah, so I think that's like, I don't, again, not being the attorney, but I would stick more to, again, what are the facts? Where did you see that? What is your understanding? And I've heard some people play what they call the Columbo approach. I'm kind of confused because I thought that you had to have the manifestation determination review meeting like as soon as you could once it's already been determined to be a manifestation of their disability. Why is it taking 10 days for us to have this meeting? Like, that's not right. Crossing into that's not the same as saying, well, you're violating the law because you, the law is, and you did this, and therefore it's a violation, or it's just, even worse to say it's a substantive violation of FAPE that you did that or something like that.
Yeah. Right. And that's a good segue into Jessica's question, which is, are we allowed to state if the school is violation of their own policies, regulations, and or student handbook? You can say that they're not following it, or where in the student handbook or the policies and procedures is the authority for that. But Whether or not it's a violation, I think I would just use a different language. You're not following your own policies. Can you say the parent may exercise their parental rights? Yes, Carly, I think you could. I think you can just say the parent, the parents are going to discuss what their parental rights are. Yeah.
Do you have any questions that advocates or non-lawyers should keep in mind when they're trying to figure out if something that they would like to do is UPL?
I would say go back to the words that we talked about in the beginning where Celine said, support or guidance. That's what the Maryland statute says in its definition of what an advocate does. So, which is different than, I guess, again, going back to that medical analogy, it's different than prescribing something or, saying that giving specific advice. So trying to keep those words and asking yourself, in what way am I supporting the family? In what way am I helping them to understand or guiding what their decision might be?
Yeah. Before I get to Jessica's question, I'll answer, the other Jessica Williams, I'll answer Jessica Grandis' question. I think that asking for information to be included in the PWN is always good practice for any of us in IEP meetings, to hold them accountable for that PWN, for the prior written notice, which we know never really happens, or is never really how it should be in what you get. So,
and I think along those lines, I would say anytime you're just asking for information that can be used to provide support or guidance to the families, like, can we have copies of the incident reports? Where we haven't received any of the behavior data. We haven't, that kind of thing. If we're just asking for information, that's okay, right?
Yeah. And I think, getting to Jessica Williams' question, can you speak to the regulations if you're a certified special education teacher? I think you can ask for clarification on what the regulations might mean to the team, but you can't interpret what those regulations are without having some difficulty, I think. I think you just need to be careful. Yeah. So I hope this was helpful.
Definitely. Thank you so much for your time and sharing all of this with us. We really appreciate it.
Sure.
Again, thank you for the opportunity. Good luck to everyone. I think this is, as we said in the beginning, it's exciting, and it's also can really serve to be a model for other states. So we're all, not to put any pressure on or anything, but we're watching a little bit.
Yeah.
Thank you so much. And for all the participants, I will be sending out all of the materials that we went over so you can have those handy as well. But thank you to everyone. Thank you especially to Denise and Celine, and I hope you all have a great rest of your day.
All right. Thank you so much.
Thanks, everybody. Good to see you. Take care.
Thank you, Celine. Bye.
Thanks.
Thank you,
Bye.
Michelle. Bye.
Bye.